Thank you, Dick, so much. And you really have no idea how how strong the connection is, because what I want to talk about is leadership, uh, and Mother Jones contrasts so sharply with the so-called leadership that we had in this country for the last 4 years. Um, and it leads into the opening of my remarks. So what I want to talk about, inspired by Dick's lobbying, is really to dig deep into accountability and what that means. Amy and her group are as private citizens, they are holding these white supremacists accountable. And more others are trying to hold people accountable. We're very hopeful that the Merrick Garland DOJ and the Biden administration will hold people accountable. But there are voices that would have us move on and heal. And I want to address that in these remarks today. And I'm going to give it a broad purview. I want to talk about Trump and holding him accountable. And I want to talk about a few of his enablers and how they need to be held accountable. And in the midst of that, I want to address some of the pushback that's already emerging against these efforts. I want to put it in a context, and the Mother Jones historical piece is important to that. But so were the founders. Now, nobody can celebrate our founders universally, given their own deep flaws and violations of human rights across the board, beginning most prominently with slavery. But the founders did provide a constitution that is a blueprint for much of what we're trying to do. But first, I want to have us listen to what kinds of leaders the founders wanted in this country. In Federalists number 57, those great papers written at the time the Constitution was being considered, James Madison wrote that the aim of every political constitution is or ought to be first to obtain for rulers men, it was men in his voice, who possess most wisdom to discern, most virtue to pursue the common good of the society. Gouverneur Morris wanted, quote, the best, the most able, the most virtuous citizens. Benjamin Franklin sought wise and good men, and James Wilson sought men of intelligence and uprightness. George Mason feared dangerous and ambitious men, and Alexander Hamilton wanted checks and balances to preclude men of little character and who love power. And the framers included impeachment and removal and disqualification to deal with, quote, corrupt and unworthy men, designing men, and demagogues, according to Elbridge Geary. So we know what the aspirations were, and from time to time, we've had leaders that approach that kind of standard, but we hardly have seen that in the last 4 years. And focusing on, and I want to applaud the efforts in the 2 impeachment trials. It was important for Congress twice to use its power of indictment, its power to set on the historical record in those 2 instances what Trump had done. I don't bemoan the fact that those articles went on to be defeated by the Republicans in the Senate in our system that requires a 2/3 majority for conviction in the Senate on grounds of impeachment. History marks Donald Trump as having twice been impeached by the House of Representatives, and especially the second impeachment with some brilliant presentations by Representative Raskin and others have created a historical record of what Trump did in inciting the insurrection on January 6th. Far more needs to be done on that. But I want to recognize that the first acts of accountability happened during the Trump administration through those actions in the Congress. But Trump lost his immunity by being defeated at the polls. And I had occasion to do a book review of a book called After Trump by Bob Bauer and Goldsmith, a Democrat and a Republican who looked at what do we need to do going forward to correct the injuries that Trump caused to our democracy, to establish laws and boundaries and guardrails for things that were too vague or were failed to be enforced against Trump, and the norms that Trump violated. But before they got to that, they wanted to ask about prosecuting Trump now. And I want to quote a few portions of what they said and a few other experts have said, because it aligns with my sense of what we must do as a democracy now. Bauer argues that Trump should face a full investigation as determined by the merits of the matter, and that he should not receive a blanket prospective pardon or free pass. Now, Bauer begins by pointing out what's already pending. The question of whether or not to hold Trump accountable is already out of the barn. There are both criminal and civil proceedings pending. There are civil proceedings pending in New York State through the courageous work of the Attorney General of New York, and there are criminal investigations pending through the work of the Manhattan District Attorney, Cyrus Vance. And I want to detail some of that. These proceedings will go forward irrespective of what Merrick Garland and Joe Biden and the Department of Justice decide to do, although we'll come to that in a moment. According to court filings, Cyrus Vance is looking into potentially widespread and protracted criminal conduct by Trump and the Trump Organization in New York, which published reports suggest may include tax fraud, insurance fraud, money laundering, and violation of New York's racketeering statute. Now, Bauer was critical, as I am, of past precedents in this area. Gerald Ford decided to pardon Richard Nixon. He said to heal the country. And that was done without any transparency and without following any clear or well-defined process. But when it comes to Trump, Bauer says sound prosecutorial judgment and tightly developed and presented cases are essential to dispel, to the extent possible, any suspicion that the law has been weaponized for political purposes. And essential to achieving these goals is the operation of law enforcement on a fully independent basis, free of partisan influence or pressure. Now, when Bauer and Goldsmith wrote their book after Trump, they had no idea what was coming on January 6th, but they already knew that on Thanksgiving Day last year, Trump called the United States a third world country due to massive fraud in the election. He declared, "We were robbed, we were robbed. I won by hundreds of thousands of votes. Everyone knows that." He continued to undermine confidence in the electoral system by claiming that if the media were honest and big tech was fair, it wouldn't even be a contest. And the next day, he renewed his threat to disrupt the peaceful transition by tweeting that Biden would only be allowed to enter the White House if he can prove his 80,000 votes were not fraudulent. Now, the problem with the precedents in this area is that in addition to what Gerald Ford did, Barack Obama reneged on his campaign promise regarding George W. Bush. Obama promised to ask his attorney general to immediately review the information and determine if an inquiry is warranted. Instead, tragically, when he got into office, Barack Obama said, "We need to look forward as opposed to looking backwards." Obama rationalized his decision by saying he had banned torture, so that chapter was over. It didn't make any sense then, and it doesn't make any sense now. What Gerald Ford and Barack Obama did remains a lasting stain on their presidencies. Ford, as I said, justified his pardon of Nixon by claiming it would help heal the country. And he entitled his autobiography A Time to Heal. Now, in my book review of After Trump, I said the following: there's certainly something soothing about the idea of healing the nation, which suggests that this is an act of mercy and compassion, and wiping the slate clean, the country can move on. But I pointed out that the idea of healing is derived from the world of medicine and psychology. It means to make the body and the mind free from injury or disease, to make one sound and whole, well again, to restore one to good health. What doctor tells a patient suffering from a serious illness or infectious disease to leave it untreated? What therapist would tell a client suffering from long-term depression to look forward and not look back? The body politic cannot heal by ignoring what ails it, leaving a cancerous organ to metastasize and spread, infecting the whole body. We need to cure disease before we can heal it. By talking about healing and looking forward without addressing the crimes of their predecessors, Ford and Obama were ignoring the serious disorders facing the country. They were not making us sound and whole and well again. Nixon was pardoned, and Bush was let to go scot-free. These were bad decisions. That presidents are in fact above the law and will not be held accountable. We cannot repeat those mistakes. And we as an organization, each of us as individually, need to be lobbying the Biden administration and the DOJ to pursue all of Trump's crimes. But the cases of Nixon and Bush were also different in many respects. Nixon resigned and accepted a pardon and receded from public life without any prospects of returning to public office. Bush had already served 2 terms as president, and he could not run again, and he eagerly left the public stage. Trump is different. Under the Constitution, and now not having been disqualified through impeachment, he can run again as early as 2024. At a White House Christmas party last December, he said exactly that to his supporters. The last pre-election Gallup poll showed that 94% of Republicans and 97% of conservatives approved of how Trump was doing his job. And we know that over 73 million Americans voted for him. And until he was taken off Twitter, he had 88 million followers. There's rumors of him starting a TV network, and he's established a political action committee, and at one point had raised $170 million. Chris Kaliza, CNN editor-at-large, reported that it's very hard to imagine anyone can keep Trump from the 2024 nomination if he wants it. Trump is doing nothing to heal this country, and he's exacerbated it recently. To fail to hold Trump accountable for federal and state crimes committed before and after he became president would serve as a dangerous precedent for future presidents and put him above the law. I think that case is strong. In the New York Times last November, Jonathan Mahler, a journalist and staff writer, took on the question, can America restore the rule of law without prosecuting Trump? I recommend you going back to the November 22nd, 2020 New York Times. I'm not going to repeat everything he said there for the sake of time, but he laid out in chapter and verse the full gamut of the potential criminal charges that Trump is facing. For example, Michael Cohen was Trump's personal lawyer and self-described fixer. Michael Cohen pled guilty to violating 2 campaign finance laws in the Southern District of New York. He testified under oath in federal court that it was Trump who directed him to arrange for hush money payments to Stormy Daniels and Karen McDougal. Trump was actually part of that investigation, but was protected by the Justice Department memo that a sitting president cannot be indicted. But he was infamously named in the prosecution filings as an unindicted co-conspirator, the famous individual one. How can the Merrick Garland Justice Department not pursue that pending criminal investigation in the Southern District of New York? There's also the possibility of prosecuting Trump for obstruction of justice and public corruption. Now, the much ignored Mueller report documented 10 acts of obstruction of justice. The case has been made in the Mueller report, which could be dusted off by the DOJ today, to pursue obstruction of justice charges against Donald Trump. In fact, as soon as the Mueller report was released, 700 former federal prosecutors from Republican and Democratic administrations signed an open letter stating that if the same acts of obstruction had been committed by anyone but the president, they would have resulted in multiple felony charges. And the journalist reports that there's broad agreement among dozens of prosecutors and legal experts that he spoke to that Mueller presented more than enough evidence to seek a grand jury indictment against Trump for obstruction. What has gained less attention is public corruption charges. According to some prosecutors, there are at least 2 possible charges for conspiracy to defraud the United States and for extortion. Indeed, as part of the first impeachment proceedings, the House Judiciary Committee identified bribery, wire fraud, and what's called honest services fraud as crimes that Trump may have committed. And of course, we know about the further crimes he committed during the election. There's something called the Hatch Act. In 1939, it was passed, which prevents federal officials from exploiting their authority for partisan purposes. This is before we get to January 6th. And although presidents and vice presidents are exempt from civil proceedings under the Hatch Act for some obscure reason, the Hatch Act has criminal provisions to which a president or vice president is not exempt, including a prohibition against using one's official authority to influence a federal election. There are manifest examples of Trump using federal resources at the White House and elsewhere to influence the election. So that section of law needs to be used against Trump. There were other commentators, which I'll skip over, who support, including a former member of the Mueller team, who believes that there are pending actions for criminal prosecutions against Trump. I want to turn quickly to January 6th, which may have sparked Dick Bunce's specific inquiry. There are specific federal statutes that should be investigated regarding what Donald Trump did in the months leading up to January 6th, his conduct on January 6th as well. There's a section of the U.S. Code for incitement of rebellion or insurrection, 18 U.S.C. Section 2383, which provides for 10 years in prison for anyone who incites any rebellion or insurrection against the authority of the United States or laws thereof, or, listen to this, gives aid and comfort thereto. Whatever people want to say about Trump's statements leading up to and on January 6th, surely he gave aid and comfort to the insurrectionists. There's a separate crime for seditious conspiracy, 18 U.S.C. Section 2384. And as we heard the power of conspiracy in Amy's remarks today, one is guilty of conspiring to oppose by force the authority of the government and by force to prevent, hinder, delay the execution of any law of the United States. That's exactly what the insurrectionists were doing on January 6th, and it's exactly what Trump was conspiring to commit. I want to mention here, and I'll turn to him briefly in a moment, Rudy Giuliani, who could be charged under these very same charges, as well as Representative Mo Brooks, Republican of Alabama, who exhorted the crowd to stop the counting of the votes in the Electoral College on January 6th. And finally, in terms of Trump and the others, there is solicitation to commit a crime of violence, 18 U.S.C. Section 373, to solicit, command, induce, or endeavor to persuade another person to commit a felony involving the threat or use of physical force. And we know that, among other things, those events led to the killing of police officer Brian Sitnick. There are ample charges. Turning to the state of Georgia, which was mentioned earlier, there are criminal charges in Georgia, and a Georgia investigation has been opened against Donald Trump for his January 2 phone call when he exhorted Secretary of State Raffensperger to find 11,780 votes. There's a crime in Georgia for criminal solicitation to commit election fraud. And there's a crime for intentional interference with the performance of election duties. And more evidence is coming out that would support a Georgia prosecution against Trump as well. Let me briefly turn to the enablers, because it's not enough just to cut the head of the snake in prosecuting and jailing Donald Trump for everything I've talked about and more. But before I say that, I want to mention for the readers in the group that this week's New Yorker magazine has a full article by Jane Mayer on prosecuting Trump. Her extensive interview of Cyrus Vance explains how he has meticulously planned the state criminal investigations against Trump. Cyrus Vance has announced that he is retiring on December 31st, but he has put in place a prosecutorial team that is highly qualified to carry on after he leaves office. And he's appointed Mark Pomerantz, a prominent former federal prosecutor, to head that prosecution. Among his excellent credentials, Pomerantz most recently was at the law firm of Paul Weiss, which Amy mentioned, and he's been defending rich and powerful white-collar criminal defendants. And now he can turn the tables and use that experience to prosecute Trump and the others in the Trump organization. And finally, Vance has hired the top forensic accounting firm of FTI to pore over the millions of documents which recently the US Supreme Court allowed Vance to get a hold of. And they are being held in a secure facility and being analyzed by those investigators. I do believe, although Cyrus Vance has always been very conservative in his prosecutions, that in the hands of these prosecutors and investigators, the Manhattan District Attorney will move ahead. For any of you who want details on that, please check out the very recent article in the New Yorker. Finally, I want to turn to those enablers. And I'm sad to say that many of them are members of my profession as lawyers. But we as lawyers have a higher duty, not a lesser duty, of ethical conduct in litigation and in our conduct as public figures. California is among all states that have a code of professional conduct. Just as an example, it is professional misconduct in California and essentially in all states to engage in conduct involving dishonesty, fraud, deceit, or reckless or intentional misrepresentation. Furthermore, the commission of any act involving moral turpitude, dishonesty, and corruption, whether the act is committed in the course of a lawyer's relations as an attorney or otherwise, and whether the act is a felony or misdemeanor, constitutes cause for disbarment and suspension. Now, many of the lawsuits that Rudy Giuliani and others brought during the post-election period were in federal court. And in federal court, there is something known as Rule 11. Every pleading and motion no pleading or motion can be brought for an improper purpose to cause harassment or unnecessary delay or needlessly increase the cost of litigation. And any claim, defense, or other legal contention must be warranted by existing law or a non-frivolous argument for extending, modifying, or reversing existing law or establishing new law. And all factual contentions must have evidentiary support, or if specifically so identified, will likely have support upon reasonable investigation. These lawsuits brought by Rudy Giuliani and Sidney Powell and the others violated Rule 11 and the ethics of these lawyers. On January 20, a nonpartisan group, Lawyers Defending American Democracy, filed a 21-page disciplinary complaint against Rudy Giuliani with the Attorney Grievance Committee of the New York State Bar. The complaint charged Giuliani with knowingly propagating a false narrative of election fraud to delegitimize then Vice President Biden's presidential victory and to undermine public confidence in the national electoral process. By February, 7,600 lawyers and non-lawyers, including a former attorney general, 14 ex-federal judges, and 36 former prosecutors at the office Giuliani once led have joined the call that his law license be revoked. The complaint against Giuliani recognizes that lawyers have every right to represent their clients zealously and to engage in political free speech. But lawyers cross ethical boundaries, quote, when they invoke and abuse the judicial process, lie to third parties in the course of representing clients, or engage in conduct involving dishonesty, fraud, deceit, or misrepresentation in or out of court. By these standards, Mr. Giuliani's conduct should be investigated and he should be sanctioned immediately. there are further charges against him. Meanwhile, in December, the State Bar of Arizona, complaints have been filed against Sidney Powell for violating her ethical rules. In December, the Michigan Attorney General, Dana Nessel, asked a federal court to consider sanctions against Powell, attorney Lynn Wood, for the baseless lawsuit they brought against Michigan. A Delaware Superior Court judge, Craig Karsnitz, took Lynn Wood to task for unprofessional conduct in the filing of lawsuits. And Representative Bill Parscrell, Democrat of New Jersey, has filed complaints against Giuliani and 20 other lawyers behind lawsuits seeking to reverse Trump's loss of the re-election and for filing frivolous lawsuits. These are very important examples of ways in which we can hold people accountable in our system, both civilly, criminally, and through disciplinary proceedings. I'm hopeful that all of us, when we have opportunities to lobby the Biden administration to hold people accountable, we cannot, as I finish up my remarks and take a few questions, we simply cannot look ahead and let this entire chapter be swept under the rug. We will face other demagogues and authoritarians in the federal and state governments and elsewhere. We are facing them now as there are efforts to whitewash this period in American history. Calling a commission to investigate is good, but hardly enough when we have these other tools at our disposal, which we must use. And I'm going to weave in right now an announcement of our program on this Sunday, Backlash to Justice, which Michael Novak and his program committee have so admirably organized. This is our program this Sunday, beginning at 2:45 in the afternoon, in the first part of which George Gascon will be on with Melina Abdullah to talk about what we're calling Backlash to Justice, the efforts of police and prosecutors to kill the reforms of George Gascon before they have any chance of succeeding. And George Gascon is joining us on Sunday. You can go to the ICUJP website. You can go to, if that is the Facebook page that's put in the chat, or if someone puts a link to our program in the chat, you can register for free. We have upwards of over 150 people that have registered for this program. This is the initiation of the 2021 programming that arose out of the retreat that the board held earlier this year. We have formed the program committee under Michael's leadership and the Outreach and Advocacy Committee under Carol Francis's leadership. These are two active committees which throughout the rest of this year are going to be organizing programs and activities to invigorate and activate all of the passion and compassion of this organization. And you'll hear more about those committees as we plan future activities. I just want to be sure that all of you join us Sunday at 2:45 for registration. The first part of the program will be George Gascon and Melina Abdullah. The second part will be focused on the question of life imprisonment without parole, which is another injustice we'll be addressing. And Grace Dernis will be chairing the second part of the program on Sunday. I want to be sure to have brought that up today, since that program happens in 2 days from now. But it is an example. Here we have an elected official that has set out a bold program of reform, of not charging juveniles as adults, of reducing enhancements for crimes, of holding police accountable. George Gascon is reviewing all police cases where Jackie Lacey failed to hold police accountable. So here we have an example of someone who was elected, who is in the spirit of a worthy public servant that our founders were looking for. And we've got to defend George Gascon when he does the right thing. We can oppose him if we believe he is doing anything that is not in keeping with his promises. I use that quickly as an example of what we can do in the broad picture of holding political leaders accountable. Susan, I'm seeing questions in the participant list.
Yeah, so we have Michael and Ruby. It is 9:20. So if Michael and Ruby, if you want to just quickly frame a question, and we'll kind of put those together and allow Steve to answer that, and then we'll go into our close.
My question was, and you'll have to excuse me, but this morning I didn't want to interrupt by, I'll be leaving pretty soon, but I'm going to be at the board meeting. What I wanted to say is you brought a lot of things together, which is the past, and then which Dick, kind of settled in. And then you've got a lot in there, Steve. You got a lot in there. But we have to work out and know what the past was, what you brought up, which is what she brought up about 79 and everything. But now it's like, we know the past is here, but hey, we're going forward. So what is it that we can do to go forward? I see the unity of people. That's why I'm here, because I see that everybody who believes comes together, because truth is truth. But I also believe, regarding the prison and everything, and me working with prisoners and everything, is that yes, life imprisonment is for some. It's for those people who are afraid and who aren't afraid of dying and do certain work. So they have to understand what life is. So that's why I believe in for certain prisoners about life. So that's all I had to say to you.
Thank you, Ruby. And Michael.
Yeah, I was saying I certainly support holding Trump and Giuliani and the rest of them accountable, and the people who specifically fomented the storming of the Capitol. I just want to urge caution about the idea of using the seditious conspiracy law, because the main recent use of that law has been to criminalize the Puerto Rican independence struggle. Albizu Campos was charged with seditious conspiracy. A lot of the more recent Puerto Rican independentistas have been charged with seditious conspiracy. So I'd be very cautious about advocating the use of it. Historically, it's basically used to make resistance to U.S. colonialism and imperialism a kind of thought crime. So the rest of what you said, I certainly, believe is, absolutely necessary.
Thank you, Ruby, and I hope you'll join us on Sunday, and we'll have a fuller examination of LWOP. And thank you, Michael. It's always cautionary. I've written about this. Conspiracy is a very dangerous power in the hands of government, and it should never be used lightly. Amy expanded on this and how it's being used in her civil case. I would underscore everything Michael says in those warnings. We have to judge each of these cases on its own facts and its own law. We do not want to set bad precedent. I think I've spoken to this group that even the question of incitement should not be expanded so that later protests that we participate in are called incitement to violence and put all of us in jail for that. So these things are tools. They depend on the hands in which those tools are wielded. And we should be very cautious in all respects that in our zeal to cut down the trees to go after the devil, we don't have the devil turn on us and we have no civil liberties to protect ourselves. I thank all of you. I thank Dick for inspiring me to do this work. I will post in our lists my After Trump book review from which a lot of this was taken, and I have a new piece on ethics being published, which highlights much of what I talked about regarding the lawyers. Thank you so much today.